For 5 minutes without objection. Each of your full written statement will appear in the record after your statement has been completed, and also without objection, all members' opening statements will be placed in the record as well. Ms. Tarangill, you're first.
Thank you. Chairman Sensenbrenner, Ranking Member Scott, Chairman Goodlatte, Ranking Member Conyers, and members of the subcommittee. Thank you for the opportunity to testify on behalf of the Department of Justice regarding the Electronic Communications Privacy Act, or ECPA. This topic is particularly important to the Department. We are pleased to engage with the subcommittee in discussions about how ECPA is used and how it might be updated and improved. Since its inception, ECPA has sought to ensure public safety and other law enforcement imperatives, while at the same time ensuring individual privacy. It is important that efforts to amend ECPA remain focused on maintaining both of these goals. During any discussions of possible changes to ECPA, it is important to keep in mind its wide-ranging application and scope. The typical scenario that comes to mind is a law enforcement agency conducting a criminal investigation and seeking a target's email from a service provider that makes its services available to the public. And indeed, ECPA is critical to all sorts of criminal investigations into murder, kidnapping, organized crime, sexual abuse or exploitation of children, identity theft, and more. But the statute applies to all government entities, federal, state, and local, when they seek to obtain content or non-content information from a service provider. This means that the statute applies not only to criminal investigators, but also when the government is acting as a civil litigator or even as an ordinary civil litigant. Moreover, the statute applies not only to public and widely accessible service providers, but also to non-public providers, such as companies that provide email to their employees. Although ECPA has been updated several times since its enactment in 1986, many have noted, and we agree, that some of the lines drawn by the statute have failed to keep up with the development of technology and the ways in which we use electronic and stored communications. We agree, for example, that there is no principled basis to treat email less than 180 days old differently than email more than 180 days old. Similarly, it makes sense that the statute not accord lesser protection to opened emails than it gives to emails that are unopened. Acknowledging these things is an important first step. The harder question is how to update the statute in light of new and changing technologies while maintaining protections for privacy and adequately providing for public safety and other law enforcement imperatives. Personal privacy is critically important to all Americans and individuals around the world. All of us use email and other technologies to share personal and private information, and we want it to be protected appropriately. Some have suggested that the best way to enhance privacy under ECPA would be to require law enforcement to obtain a warrant based on probable cause to compel disclosure of stored email and similar stored content information from a service provider. We believe that this approach has considerable merit, provided that Congress consider contingencies for certain limited functions for which this may pose a problem. For example, civil regulators and litigators typically investigate conduct that, while unlawful, is not a crime. But criminal search warrants are only available if an investigator can show probable cause that a crime has occurred. Lacking warrant authority, civil investigators enforcing civil rights, environmental, antitrust, and a host of other laws would be left unable to obtain stored contents of communications from providers if they could no longer use a subpoena. Reform efforts must also account for existing practices as to entities such as corporations that provide email to their employees. Investigations of corporate malfeasance, both civil and criminal, have long been conducted by subpoena. For example, it is settled law that a government investigator may use a subpoena to obtain corporate records, such as memoranda, letters, or even printed emails. It would be anomalous for ECPA to afford greater protection to electronic corporate records than to the identical records in hard copy. To be clear, it is decidedly not our view that subpoenas are blanket substitutes for warrants. But in the narrow context of corporate investigations, it is important to remember that subpoenas are the norm for obtaining business records, and creating a different standard for different means of communications would hamper many such investigations. Finally, we also believe that there are a number of other parts of the statute that may merit further examination as you consider ways to update and clarify the statute, and I have noted some of them in my written statement. The Department of Justice appreciates the opportunity to discuss this issue with the subcommittee, and I look forward to your questions here today.
Thank you very much. Mr. Littlehale.
Chairman Sensenbrenner, Ranking Member Scott, Chairman Goodlatte, and Ranking Member Conyers, members of the subcommittee, thank you for inviting me to testify. My name is Richard Littlehale, and I'm Assistant Special Agent in Charge of the TBI Technical Services Unit. I also serve on the Technology Committee of the Association of State Criminal Investigative Agencies, and I'm representing their position today. I'll make 8 points very briefly, and I welcome your questions if you'd like to explore them further. First, setting the standard necessary for government to obtain content is just the first step. We also have to make sure we can actually get it. To date, much of the attention given to the question of lawful access to stored content has focused on the level of proof required for law enforcement to obtain it. The reality is that legal barriers are not the only ones that keep communications records out of our hands. Technological barriers and a lack of a mandatory compliance framework regarding service provider response slow our efforts as much or more as a change in the standard of proof might. I urge you to ensure that whatever standard of proof you decide is appropriate, you also ensure that law enforcement can access evidence reliably and quickly. Second, timeliness and quality of service must be addressed. There is no requirement in current law that compels providers to respond in a timely fashion to our legal demands. Some respond relatively quickly, but others do not. In particular, this sometimes prevents us from efficiently processing large volumes of leads, like cyber tips from the National Center for Missing and Exploited Children. In those leads, there may be an emergency, but we cannot know about it until we get the routine response back from the service provider. Speed is important. A reasonable legal mandate for responsiveness should be considered as a part of any ECPA reform proposal. Third, emergency provisions. Law enforcement must have rapid access to communications evidence in a life-threatening emergency, but that isn't always the reality. The emergency provision in today's ECPA is voluntary for the providers, not mandatory. Even when emergency access is granted, there is no guarantee we will get the records immediately. In some cases, there is insufficient service provider compliance staff to process these requests quickly. In other cases, providers have chosen never to provide evidence in the absence of legal process, no matter the circumstances, and the current emergency provision does not preclude this. Fourth, notification requirements. Requiring law enforcement to seek additional process to prevent providers from informing customers of the existence of a demand is a labor-intensive process. We urge the committee to carefully balance the need for notification and reporting against the practical resource burden it places on law enforcement. Fifth, records retention. Some cellular service providers claim they do not retain text messages for any time at all, or retain them for very short periods of time. Billions of texts are sent every day, and some contain key evidence about criminal activity. I urge you to find a balance on retention policy that is not overly burdensome to service providers, but that ensures that law enforcement can obtain access to critical evidence with appropriate legal process. Sixth, preservation. Preservation under Section 2703 has been offered by some as an alternative to records retention. But some service providers have a stated policy of notifying customers of the demand unless a court tells them not to. A 2703 preservation request does not allow law enforcement to gain access to information, but merely ensures it exists when we serve appropriate process. There should be no customer notice for preservation. Seventh, the definition of content. Definitions of content and non-content information need to be clear and comprehensive. Congress determines that any kind of content whatsoever requires a probable cause standard of access, then ECPA should define content explicitly and not infer it from less explicit definitions in other parts of the code. Finally, the volume of law enforcement legal demands. Recent media reports have expressed alarm that the number of law enforcement requests for communications evidence is growing. Of course the requests are growing, because today is a rapidly growing percentage of the available evidence in any criminal case exists in the digital world. Google's Transparency Initiative puts the volume of law enforcement demands in perspective. In June of 2012, Google claimed 425 million individual account holders for its Gmail service. In the US, Google reported of just over 16,000 government requests affecting over 31,000 accounts. That means a tiny fraction of 1% of Google's accounts were affected by government demands. And given that there are 17,000 law enforcement agencies in the United States, on average, there was less than one request for information per law enforcement agency per year for Google records. It's hard to conclude from these numbers that law enforcement demands were excessive. I will close by reemphasizing the importance of ensuring that law enforcement concerns about access to evidence become a central part of this ECPA reform discussion. My fellow electronic surveillance practitioners and I are well aware of the need to balance privacy and public safety, and we look forward to working with the subcommittee to get ECPA reform right. Thank you for having me here, and I look forward to your questions.
Thank you very much, Professor Kerr.
Chairman Sensenbrenner, Ranking Member Scott, members of the subcommittee, thank you for the invitation to testify here this morning. I wanted to focus on the constitutional issues raised by the Stored Communications Act. As several of you noted in your opening statements, the leading cases so far in the lower courts indicate that the Fourth Amendment fully protects the contents of email and other remotely stored files in the cloud, meaning that the constitutional standards, or the standards adopted by the statute in 1986, are currently below the constitutional threshold. So one reason, pressing reason to amend the statute is because the Constitution requires more privacy protection than current statutory law requires. The lower court case law is, as of yet, not fully developed. We have one significant decision from the Sixth Circuit Court of Appeals. We don't yet have a decision from the United States Supreme Court. And also, we're still in the beginning stages of getting case law on fact patterns beyond email. So, for example, in addition to storing contents, remotely stored contents by email, individuals may have stored Facebook messages, Google documents stored in the cloud, lots of information that's available on remote servers that doesn't fit the specific category of email. The lower court cases so far suggest that they are also fully protected by the Fourth Amendment's warrant requirement, but as of yet we don't have a lot of case law in the lower courts to indicate whether that's the case. I think it is correct, though. I think it's difficult to distinguish between email, for example, and Facebook messages and documents in the cloud. In my view, they're all protected under the Fourth Amendment under the reasonable expectation of privacy test. The difficulty then with the existing statute is not only that it is below the constitutional threshold, but that because it is below the constitutional threshold, it actually becomes significantly harder for the constitutional protections to be recognized, thanks to the good faith exception to the, under the Fourth Amendment, when the government relies on a statute that allows a search or seizure. The key case here is another 1986 decision, Illinois versus Krull, which held that when the government reasonably relies on a statute that might be considered constitutional, the exclusionary rule does not apply under the good faith exception. What that means as a practical matter is that the existence of ECPA actually makes it harder to recognize constitutional rights. It actually cuts constitutional protection rather than adds privacy protection, because the government, under current law, can rely on the good faith exception to rely on the statute to obtain contents with less process than a warrant. As the case law becomes more established, it will be harder for the government to do that. But ironically, the existing statute actually makes it harder for Americans to recognize their constitutional rights and to get those constitutional rights recognized in cases than there would be if there were no statute at all. Ultimately, the ECPA statute was designed to fill in constitutional protections where at the time, in the 1980s, it was not clear how the Fourth Amendment would apply. So it may be that as we get more and more case law establishing those Fourth Amendment protections, there's less and less of a need for statutory protections that regulate that same territory. And at the very least, it's important for those statutory protections to not be below the threshold of the constitutional protection in light of the good faith exception. I also wanted to address a few aspects of the Justice Department's testimony. I think it's very significant that the Justice Department is taking the view, agreeing generally to the idea that there needs to be a rewrite of this statute and that there is merit to the idea of a general warrant requirement. The Justice Department's testimony, testimony suggests that there are two potential exceptions to that, one of which I think is justified and one of which I'm skeptical about. The one that I think is justified is allowing a subpoena authority when the government is investigating a company and its own email services in the corporate crime context, where traditionally the Justice Department and state prosecutors as well have relied on subpoena authorities to investigate, say, a company engaged in some sort of white-collar crime. I think it makes a lot of sense to have an exception to the general warrant requirement for that particular context. On the other hand, I'm skeptical about the idea of having civil discovery subpoenas widely used in the ECPA setting. I don't think we want to have our service providers turned into essentially places where anyone who files a civil lawsuit can go and get somebody else's email to look through in a routine civil investigation. Maybe there's some reasons to treat federal government investigations differently in some cases, but I think it's dangerous to allow providers to be used in this way. In general, in civil litigation, it should be that people go through the parties, not through service providers. Thank you, and I look forward to your questions.
Thank you very much. Mr. Salgado.
Chairman Sensenbrenner, Chairman Goodlatte, Ranking Member Scott, Ranking Member Conyers, and members of the subcommittee, thank you very much for the opportunity to appear before you this morning. I'm Richard Salgado. As Director for Law Enforcement and Information Security at Google, I oversee the company's compliance with legal requests for data, including those submitted under the Electronic Communications Privacy Act of 1986, otherwise known as ECPA. In the past, I worked on ECPA issues in my capacity as senior counsel in the Computer Crime and Intellectual Property section in the Department of Justice. In 2010, I appeared before what was then the House Judiciary Subcommittee on the Constitution, Civil Rights, and Civil Liberties. When I spoke then, I highlighted the numerous ways in which the Internet has contributed to our economy and our society as a whole. Today, not surprisingly, the impact is greater. In addition to the millions of jobs that have been created, the Internet economy accounts for almost 5% of our gross domestic product, according to a recent Boston Consulting Group study. The Internet has put information and opportunity at the fingertips of millions of users, and we need updated laws to allow this ecosystem to continue growing. On a nearly daily basis, I see the challenges created by ECPA. In 2010, Google launched a transparency report which details the volume of requests for user data that we received from government entities. In the last half of 2012, the number of requests Google received from government agencies in the United States in criminal cases more than doubled compared to the same period in 2009. ECPA was passed in 1986 when electronic communication services were in their infancy. With the dramatic changes that we've seen since then, the statute no longer provides the privacy protection that users of these services reasonably expect. And one example that the committee may already be familiar with is from the ECPA rules around compelled disclosure of email. As a general rule, law enforcement under the statute needs to obtain a warrant to compel an electronic communication service provider to disclose content that is held in electronic storage, as that term is defined in the statute, for 180 days or less. Once that message becomes 181 days old, it loses that level of statutory protection, and a government entity can compel its disclosure with a mere subpoena, which of course is issued on a much lower standard than a search warrant and without any judicial review. I'll also note that the Department of Justice has taken the position that government can use a subpoena to compel the production of email that's been opened, even if it is younger than 181 days. It's a position that has been rejected by one court of appeals in the federal system. If one could discern a policy rationale for this 180-day rule in 1986, it's not evident any longer and contravenes users' reasonable expectations of privacy. We're encouraged to hear that the Department of Justice seems to acknowledge this as well. In fact, the Sixth Circuit in the latter part of 2010 held that ECPA violates the Fourth Amendment to the extent that it allows government to use legal process less than a warrant to compel the production of content from a service provider. Google believes this is correct, and to the extent ECPA provides otherwise, it's unconstitutional. The 180-day rule reveals the gap between where the statute is and where users' reasonable expectations of privacy lie. The privacy protection afforded to email content from law enforcement shouldn't vary based on a communication's age or its open state. ECPA should be updated to require a warrant to compel the production of any content. Updating ECPA should be a top privacy priority for the 113th Congress, and Google is not alone in taking this view. More than 80 companies and organizations that span the political spectrum are now members of the Digital Due Process Coalition, which supports updating ECPA. And these include American for Tax Reform, the American Civil Liberties Union, Center for Democracy and Technology, the Competitive Enterprise Institute, and the U.S. Chamber of Commerce. Notably, these organizations don't always agree on other privacy issues, but they are united in the effort to support updated provisions in ECPA for the requirement of a warrant for the production of content. As the benefits of Internet computing become more obvious, including the data security benefits, the growth of the Internet shouldn't be artificially slowed by outdated technological assumptions that are currently baked into part of ECPA. And the progression and innovation in technology shouldn't be hobbled by pre-Internet ECPA provisions that no longer reflect what users should expect. We look forward to working with this subcommittee and the full Judiciary Committee and Congress as a whole to update the statute. Thank you for your time and consideration. I'd be happy to answer any questions.
Time of the gentleman has expired. The chair will withhold his questions until the end and now recognizes the gentleman who is the chairman of the full committee, the gentleman from Virginia, Mr. Goodlatte.
Thank you, Mr. Chairman. Let me direct this question to each of you. To obtain a document from someone's home requires a warrant. When the same person gives and stores that document with another person or company, a subpoena can be used to obtain it. What is an individual's expectation of privacy when electronic documents are stored with third parties? Why should stored electronic communications be treated any differently under the Fourth Amendment? We'll start with you, Ms. Tarangil. Is that how you pronounce your name?
Tirangel.
Sorry, thank you.
That's okay. So as to what can be obtained in what circumstances, the Fourth Amendment is very fact-specific and dependent on circumstances. So with that caveat, in obtaining documents from someone's home, there are certainly, if there's a desire to go in and compel that document, there can be a search warrant used. You can also subpoena people to bring you documents that they have in their home. So depending on the circumstances, even in the paper world, there can be permutations of what rules apply. With respect to what the standard should be for electronic communications, we have suggested that many have advocated on behalf of a warrant requirement for the government to compel stored communications from providers. And in those circumstances, as a general matter, we think that idea has some merit, and we understand the appeal of that. And
let me interrupt because I've got a lot of people and a couple more questions. Mr. Littlehill.
Mr. Chairman, I welcome the question, and I would suggest that it suggests that even beyond ECPA, search warrant law, statutory search warrant law in general, is also a little bit behind the times in terms of technology. For example, if I serve a search warrant on a residence, then it is up to me and the fellow agents that we take in there to determine what we're going to take. We decide what we're going to get, and we get it and we leave in a quick fashion, or as quick as we choose to, as quick as we choose to expedite that warrant. On the other hand, even if the committee chooses that law enforcement needs probable cause to obtain these records, we're at the mercy of the service providers to determine how long it's going to take them to comply with that request. So in keeping with my testimony, I would suggest that whatever the level of standard of proof, the thing that really matters most to those of us in state and local law enforcement
is prompt response. Professor Kerr?
Mr. Gillette, the answer in the physical world would really depend on whether the documents that you handed to the other person were sealed or not. If it's an open set of documents, you would be relinquishing your expectation of privacy. The government could get that information from the other person without a warrant. If it's sealed documents, for example, in a sealed envelope or a sealed box, then it would be protected.
So if it's stored in the cloud but no one else has access, so is that the equivalent of a sealed document?
Yeah, I think it is the equivalent of a sealed document, and that is the right analogy that the Warshak Court adopted.
Thank you. Mr. Salgado?
Mr. Chairman, we don't see a distinction there, that there needs to be Fourth Amendment protection to documents that a user stores in the cloud, just the same as if they had stored them in their office or their home. The reasonable expectation of privacy of the Fourth Amendment requires that result, and we would like to see ECPA updated to reflect that.
All right, and then to follow up on Professor Kerr's statement, we'll ask both of you. So is there a diminished expectation of privacy when a document is stored in the cloud but multiple people have access to it for editing purposes or for whatever purpose?
No, there is no diminished expectation of privacy in the same way that there would be in a group. If you live with several other people in your home, there's still warrant protection for the home. In the physical world, the slight exception to that would be that other people who share the space can consent to the government going in and looking at your stuff. And where ECPA plays an important role is in Section 2702, limiting the ability of the provider, that is the sort of third party there, from voluntarily disclosing information to the government. So it's a very important protection that effectively recognizes the fact that in the cloud, it's the provider who has access to the information and also the user who has access. Very
good. And Mr. Salgado, would you elaborate on some of the in-the-cloud services that are currently being marketed by Google and by others? And will a higher standard for law enforcement to access the information stored in the cloud make such a service more attractive to consumers? And similarly, will it make it more attractive to criminals?
Thank you, Mr. Goodlatte. Yeah, the answer is yes. The services that we offer are very popular, but the failure of current law to keep up with reasonable expectation of privacy has been a drag on the adoption of these services, and there's certainly resistance to it both in the United States, but also for markets outside of the United States where customers may be concerned that the U.S. government has access to the materials and with a standard that's lower than what they ought to expect, the users ought to expect. Some of the services that we could point to as examples of this include, of course, the Gmail product, but there's also other services like our YouTube video upload and viewing service, Docs, which allows users to collaborate on the drafting and editing of documents, Blogger, which is a very popular site for the publication of blogs, which can at times be private or shared among a limited group of people.
And what about criminals?
I'm sorry?
Criminals, the other part of my
Oh,
question.
thank you.
I don't
Yes.
want to.
Well, we certainly recognize that the services we offer can be misused. There are some miscreants out there who will, whatever communication service is available, find ways to turn it to against the good. And we are very much in favor of an amendment to ECPA that still allows law enforcement to conduct the investigations it needs and to fulfill its important responsibilities.
The gentleman from Virginia, Mr. Scott.
Thank you, Mr. Chairman. And I'd like to follow up on this, Mr. Salgado. Do people generally know where the email is physically stored, and should that make a difference in terms of the privacy expectations?
Mr. Chairman, I don't think people necessarily know where their email is stored. Part of the reason for that, of course, is the, if you will, the magic of the cloud as it is, which is by having data spread throughout lots of data centers in different locations. Even the existence of a single email may itself have been scattered among different data centers to provide for security, for robust services, to reduce latency. The rules around disclosure of the data shouldn't have anything to do with the location of it, which is in some sense driven by the physics and architecture of the internet and not by choice of users or companies. It's more to make the
And
product.
should that affect the expectation of privacy? I mean, you would expect the email to be private, whatever Google does with it.
That's right. We agree with that the email ought to be private regardless of where it's located, and the state of its storage or the age of the message itself.
Professor Kerr, you mentioned the case law is being worked on through the courts. How much of that case law is statutory interpretation, which we could clearly clarify, and how much of it is constitutional law that we'd have no control over?
Well, the case law that I was referring to was constitutional case law. So we have the Sixth Circuit Court of Appeals, a few district courts, a few state intermediate courts. Those are Fourth Amendment interpretations governing email, which of course Congress could not change.
Thank you. Mr. Littlehill, you mentioned, referred to content and said you might want to say a little bit more about it. Are there different levels of information that we're talking about, where there's the fact that the email was sent or the content of the email, and there ought to be possible different standards for that?
Well, the first level of categories that I would suggest we need to be cautious of is, as we reform ECPA, is making a clear distinction between the actual content of a communication, the substance of the communication, and signaling and routing information, stored transactional information that law enforcement can use, we believe, at a lesser standard to whether it is determine the pattern of contact between two individuals, what communications technologies they're using, use that as a component of probable cause to further our investigation. So in my oral remarks, I was referring to clarifying the standard of content, so whatever the level of access we determine for content, we're sure what content is.
Ms. Tarangel, is there a problem now with the emergency provisions and getting information?
That is not something on which we have an administration position here today. We're certainly happy to talk further with you about the robustness of the emergency provisions and whether any situation.
You have access to information on an emergency basis now. You mean you could skip a couple of steps if there's in fact an emergency. Has that been a problem?
So currently the law allows for an exception for life and limb, essentially when there is physical harm or danger to physical life. With respect to Mr. Littlehill and the additional emergencies that might be necessary. We don't have a position on that right now, but we're eager to discuss the matter with Congress and with the subcommittee and find a way forward.
Is there any problem with, in civil litigation, you can get a lot of information that may not have been able to be obtained on a criminal warrant. Is there any, if someone obtains information through civil litigation, can that be converted into criminal evidence?
So with respect to what we are suggesting that Congress consider, there would be much opportunity, and in fact there would need to be an opportunity to consider the means by which information could be used between civil and criminal. That is, in suggesting that there be an opportunity for civil components to obtain contents of email, there would still need to be discussions about how the practicalities of that would play out. So there are currently, and it depends on context, ways in which information is passed from civil to criminal, but it need not always be the case dependent on the situation.
Thank you, Mr. Chairman.
Thank you. Gentleman from North Carolina, Mr. Coble.
Thank you, Mr. Chairman. Thank you for calling this hearing, Mr. Chairman. Thank the witnesses for appearing. I was going to start with Chairman Goodlapp's first question, so you beat me to the punch, Bob. Let me go to another. Mr. Littlehill, is there any evidence at all that even hints that the current law in place since 1986 has in any way inhibited either the development or the use of the internet or other technologies?
I'm not aware of any, no, sir.
Any other witnesses? Professor?
I think it's a difficult question to answer because, of course, it's a counterfactual issue. We don't know what the world would look like if the statute were different. So I think it's just a difficult question to answer one way or the other.
Thank you, sir. Anybody else want to be heard on it?
You know, for companies like Google, and there are others that have been following Warshak for a couple of years, we actually have seen what the world looks like, where it's a warrant requirement for content. So we've had that for a couple of years now. I'm not aware of this presenting any difficulties in any context.
I thank you for that. Mr. Littlehill, this may have been discussed, but let me try it again if it has. Do heightened legal standards result in a slower police response, which may have real life or death consequences? And if so, give me an example.
Well, sir, let me begin by saying that the case that was discussed earlier, Tennessee is in the Sixth Circuit. So for us now, we live under a probable cause standard for all stored content. Having said that, in talking with practitioners across the country, there are some who believe that the 180-day distinction is appropriate and should remain, and others who do not. I will say that, again, returning to my earlier point, anytime you talk about raising the level of proof, in some cases, you do reduce the number of leads we can process in the same amount of time. If that is the will of Congress, certainly we will operate within those parameters, but we also would urge you that if there are going to be proof, the levels of proof are going to be raised, and we are going to be able to process a large number of leads a little bit slower in that context, that if you can give us assistance in these other areas, timeliness of service provider response, records retention, and so on, then that will allow us to contract the investigative timeline and make sure that we're able to perform our responsibilities even with a higher standard.
I thank you, sir. Anyone else want to be heard on that? Thank you all for being with us today. Thank you, Mr. Chairman. I yield back.
Thank you. Gentleman from Louisiana, Mr. Richmond.
Oh, thank you, Bob.
Thank you, Mr. Chairman and Ranking Member, and especially for calling this meeting today. And I'll just pick up where I left off because, Mr. Littlehill, I've heard you mention timeliness of response a number of times. So I guess my question would be, if we went to almost like a subpoena type model for some things, wouldn't it be up to you all to request the return or a judge to give that date by which the provider has to respond to the subpoena?
Well, sir, partly that depends on which statute we're proceeding under. Under ECPA, there are provisions for state orders to have federally expansive effect. That's going to vary from state to state, whether we are permitted to require a certain response or not. I'm certainly aware of a number of instances over the course of my career where, regardless of what the court order said on it or what the subpoena said on it, the response was still delayed. And frankly, again, as a practical matter, as a practitioner, is it worth my taking my time and prosecutors' time away from investigations in order to seek a motion for a show cause hearing, try to bring a provider into town? Very often, we just don't have the time to do that. So often, we just live with what we can get. So regardless of the level of process, a universal mandate for some more structured form of service provider response is critical to our effectiveness.
Right, but it would still have to have teeth in it. I mean, we can have a mandated time that they have to respond, but if you're telling me that if they ignore it, you have to make a decision whether it's worth your time and energy and using an agent to go to court to do a motion to compel or contempt hearing, then whether we put a date in or not, you would still have to make that decision.
Yes, sir. I think a mandate would have several benefits. First, it would allow all service providers to build to the same standard, as opposed to the situation we have now where some make different corporate choices than others and may be penalized because of it. The truth is, we would prefer to work with the service providers, and of course the law enforcement electronic surveillance community has historically. We would rather resolve this in a cooperative manner and find a mandate that they could all build to, rather than make it an adversarial situation, because the truth is we depend on these people every day to partner with us, save the victims, and get us the information we need.
Now, and anyone can answer this question because in fact, we're talking about the subpoena aspect of it now. One thing that I like about subpoenas, at least in my practice, that if the person whose records you're asking for feels that it's just a fishing expedition or some other violation of their rights, they have an option to file a motion to quash or go see a judge or a court of jurisdiction to say, this is just a fishing expedition and I don't want to do it, and then have a judge make a determination. How do you all envision encompassing that same protection or same right in what we're talking about now? Mr. Curry, yeah, I see.
I think it depends on whether we're discussing a probable cause-like regime, a traditional warrant approach, or a subpoena that's not based on probable cause. If it is a subpoena approach, then generally there would need to be some prior notice. The current ECPA statute allows for prior notice, requires prior notice when the government is pursuing a subpoena, but then allows for delayed notice, which unfortunately is obtained in the routine case. As a result, nobody ever finds out that their emails are being accessed, or at least doesn't find out till much later if they are ultimately notified. As a result, you don't see those challenges, which should be available. Under the warrant authority, and this is, I think, a complex question, if the government proceeds under the warrant authority, what notice should there be? The current statute says if the government obtains a probable cause-based warrant, there's no notice requirement. Of course, there's notice to the provider,
right,
but not to the user.
Well, under a warrant, the theory is that you have an independent person who has looked at it and determined that, one, it's reasonable, two, there's probable cause, and it's not a fishing expedition. So now my question is, with the delayed notice, what standard is there for law enforcement to ask for and receive the ability or permission to do delayed notice as opposed to allowing the provider to immediately notify someone that their emails have been requested, seized, searched, or whatever?
Yeah, the exact phrasing of the statute is, I can't recall off the top of my head, but it's essentially if it would interfere with an ongoing investigation, and of course, notice to a suspect could interfere with a lot of investigations, possibly. So that is obtained, unfortunately, pretty routinely, and the notice requirement written into the statute, unfortunately, ends up being a non-notice requirement in practice.
Well, I see my time is expiring, and Ms. Taranja, if you could just at some point think about, and you don't have to answer it now, just how do we do it in the regulatory scheme in terms of enforcement without hampering the government's ability? Thank you, Mr. Chairman.
And Ms. Triangle, if the Justice Department can answer Mr. Richmond's question promptly without objection, we will put that answer in the record, because all of us would like to know that. Gentlewoman from California, Ms. Chu.
Thank you, Mr. Chair. Ms. Triangle, in your testimony, you raised the point that if ECPA is amended to require the government to get a warrant to compel a service provider to disclose private communications, that this would hinder civil investigations. And you say that since civil regulators and litigators lack warrant authority, they'd be left unable to obtain stored contents of communication from providers. I'm trying to understand the scope of the problem if this is the case. Do you know how frequently civil investigators try to obtain information from third-party service providers? Why couldn't they just get a subpoena for emails directly from the party? And in fact, wouldn't it be more likely the case that they would do such a thing? In other words, is the frequency more or less than the request for criminal investigators?
So thank you for that question. There are a couple of reasons why going to a subscriber directly isn't a reliable way of always getting the content that is being sought. One is there are times when the subscriber has gone out of business, is bankrupt, is deceased. Another reason is that occasionally, or with some frequency, a subscriber will deny ownership of the account or of the communications at issue. And a third is that there are also those who would violate the law may be tempted to destroy rather than hand over evidence to the government. So those are a couple of reasons why going to a subscriber directly doesn't solve the problem. And perhaps a couple of examples would point this out. For instance, in a civil rights investigation, if a landlord sends racially harassing texts to tenants and the tenants delete them because they recoil and their first instinct is to get them off their phone, and the landlord denies having sent those emails and denies ownership of the account, the Stored Communications Act is going to govern whether the government can get those emails. In the False Claims Act context, when the Civil Division is seeking information about a fraud perpetrated on the government and wants to get emails that it has reason to believe exist that show the fraud was perpetrated, but the corporation says, we don't actually use email for business purposes. The Stored Communications Act is going to govern that as well. So I could provide additional examples, but those are the sorts of ways in which civil investigations and suits would be impacted.
Well, for email in transit, you have to have a warrant. For email in storage, you have to have a warrant. For email in remote storage, stored for 180 days or less, you have to have a warrant. So don't you have to have probable cause anyway?
So the laws on ECPA is somewhat complicated on this point. That is, with respect to email that is older than 180 days and opened or unopened, a subpoena under ECPA would suffice. With respect to email that is unopened and younger than 180 days, you would need a warrant. And with email that is opened and younger than 180 days, ECPA provides for a subpoena. Now, there is case law that is layered on top of that, but there are different rules that apply in different scenarios. And one of the things that we have said in our written testimony is we recognize that these 180-day rules and the open-unopened distinctions haven't kept pace with the way technology is used today.
Yeah, but my point is you have had to prove probable cause for these other cases that are 180 days or less.
So in a small category of cases under ECPA, there is currently a warrant requirement, but in a larger category of cases under ECPA, there is a subpoena requirement. If your question is how after Warshak the department is operating, the answer in part is that civil components are already feeling this harm, and it is harmful.
Well, do you have a solution to deal with this disparity between the civil and criminal investigations?
So we are asking that Congress, or suggesting that Congress could consider formulating a contingency to ensure that civil regulators and litigators can do their work effectively. We don't have a specific proposal on that here today, but we're eager to discuss that further with you as you move forward.
And Mr. Salgado, do you have a sense for how many requests received by Google are from civil investigators?
Chairwoman, we don't have a specific breakout for those types of requests. I can tell you that Google would not honor subpoenas for the production of content from government agencies, civil or criminal. Our understanding is that the civil agencies get the content through other means, more precisely through the customer directly after subpoenaing Google to identify who the subscriber is.
The gentlewoman's time has expired. Gentleman from Texas, Mr. Gomert.
Thank you, Mr. Chairman. Thank you to the witnesses. Professor Kerr, nice to see you back. Mr. Salgado, I was curious, doesn't Google sell information acquired from emails to different vendors so that they can target certain individuals with their promotions?
Mr. Congressman, no, we don't sell email content. We do have a system similar to the system we use for scanning for spam and malware that can identify what type of ads are most relevant to serve on email messages. It's an automated process. There's no human interaction, and certainly the email is not sold to anybody or disclosed.
So how do these other vendors get our email and think that we may be interested in the products they're selling?
They don't actually get your email. What they're able to do is through our advertising business, be able to identify keywords that they would like to trigger the display of one of their ads, but they don't get information about who the user is or anything.
Okay, well that brings me back. So they get information about keywords in our emails that they use to decide who to send promotions to, albeit automatically done, correct?
The email context is used to identify what ads are going to be most relevant to the user.
And do they pay for the right or the contractual ability to target those individuals that use those keywords?
I might phrase that slightly differently, but the gist is correct, that advertisers are able to bid for the placement of advertisements to users who our system has detected might be interested in the advertisement.
Okay, so what would prevent the federal government from making a deal with Google so they could also scroogle people and saying, I want to know everyone who has ever used the term Benghazi, or I want everyone who's ever used, a certain term. Would you discriminate against the government, or will you allow the government to know about all emails that included those words?
Sir, I think those are apples and oranges. I think the disclosure of the identity...
Well, I'm not asking for a fruit comparison. I'm just asking, would you be willing to make that deal with the government, the same one you do with private advertisers, so that the government would know which emails are using which words?
Thank you, sir. I meant by that it isn't the same deal that's being suggested there. We certainly wouldn't...
But I am asking specifically if the same type of deal could be made by the federal government. Heck, the same government that'll make a commercial and pay for it to air overseas saying we had nothing to do with the video, which we know now had nothing to do with Benghazi. But if that same government will spend tens of thousands of dollars to do a commercial, they might, under some harebrained idea, like the idea of cutting a deal with Google to get all the addresses, all the email addresses that use certain words. Couldn't they make that same kind of deal that private advertisers do?
We would not honor a request from the government for such a...
So you would discriminate against the government if they tried to do what your private advertisers do?
I don't think that describes what private advertisers...
All right. Does anybody here have any, obviously, you're doing a good job protecting your employer, but does anybody have any proposed legislation that would assist us in what we're doing? I see my time is running out. I would be very interested in any phrase, any clauses, any items that we might add to legislation or take from existing legislation to help us deal with this problem. Because I am very interested and very concerned about our privacy and our email.
Well,
Thank you very
if
much.
the gentleman will yield, I'm sure as this debate goes on, we will be getting a lot of advice from a lot of different sources, some of which will be trying to twist the law in favor of somebody or another. So stay tuned, gentlemen from
And just so that the simpletons that sometimes write for Huffington Post understand, I don't want the government having all that information.
Well,
Thank you. I yield back.
You know, I'll, with a point of personal privilege, my son writes for the Huffington Post.
Well, then maybe he's not one of the simpletons I was
He
referring to.
does have a PhD, a gentlewoman.
Well, you can
from
still be a
California.
PHUL.
Thank you, Mr. Chair. I wanted to ask a couple of questions. One of Mr. Salgado from Google. You said that the criminal cases that are investigated have doubled the requests, and I was wondering if you could give me some examples of the type of cases, and then also why do you believe that the numbers have doubled?
Thank you, Congresswoman. The types of cases that we see come in the form of legal process are a huge variety of cases. We've certainly the cases you'd be very familiar with. You might have seen press reports on those types of cases are very common. Kidnapping cases, child exploitation, fraud cases. You could almost open up Title 18 of the U.S. Code and walk through it, and at some point in the history of Google, there will have been some request about one of those crimes charged there. I must say that the legal process we receive very rarely describes the case that's under investigation. So on your average legal process, we don't actually know what the crime is that's under investigation. As to the second part of the question as to why we might have seen such an increase, it's a little bit speculative. I think part of that, though, is likely the result of the fact that our user base has grown. And as a necessary sort of result of that, or inevitable result of that, there's going to be some more accounts that are used or have evidence relating to criminal conduct.
Thank you. Thank you. I appreciate this. And this might be for you, or it also might be for Ms. Trangel. There we go. You know, there's the website Backpage. And Backpage, everybody knows, is involved in sex trafficking, and especially sex trafficking of minors. And I wanted to know how we can get at that. So, for example, if anybody monitors Backpage, there's emails that go back and forth requesting the services of the females that are advertised there. And what role can the Justice Department have in terms of trying to shut that down, where you know it is taking place? And I don't know if the federal government routinely investigates that or what. I know that Craigslist used to do the same type of advertising, and they stopped after public pressure. But because of First Amendment rights, of course, it's difficulty to shut it down. But when we know that there's criminal behavior taking place and it's on display.
Thank you for that question. I'm not sufficiently versed with the specific facts of Backpage to answer to that circumstance with particularity, and if there were an ongoing investigation, I wouldn't be able to speak about it in any event. But I can tell you with respect to sex trafficking and other sorts of crimes that the government is investigating and trying to learn more about, the government depends not only on the kind of content that we've been talking about here today, but also non-content information that forms the building blocks of investigations. And part of why ECPA is so important, and part of why all the reform efforts should take into account not only privacy but also government needs and its law enforcement needs, is because it's used with such breadth, and it's used for non-content, it's used for content, it's used for civil cases, it's used for criminal cases, and then within those categories for a wide variety of things. So
what do you mean by non-content?
Non-content can range all the way from basic subscriber information and things like that to information about the way people use sort of the traffic that they use. And there are different standards that apply to different kinds of non-content. But these are the sorts of things that can form the building blocks of investigations that allow us to focus on the right people, that allow us to free others from suspicion, and then allow us to build to probable cause to a place where we can go get a search warrant or where we can make an arrest.
Well, one of my concerns about the females, or the girls, I should say, because they're not adults, is that many of them are in the child welfare system. And so that means technically the government has removed them from home, which means we're in charge. And so I'm wondering if there is any coordination between the federal government and, well, DOJ rather, and child welfare departments.
Certainly, I'm aware of coordination that occurs between federal law enforcement and state jurisdictional enforcement so that they're talking to each other. So I think there is some coordination going on with respect to that. Whether there's direct communication between the federal authorities and the child welfare authorities, I can't speak to. But I'm happy to try and find out more and get back to your.
All right, I would.
The gentlewoman's time has expired. The chair will recognize himself for a final series of questions. Let me say that to amend ECPA, we're going to need to have a balancing act, which means that neither law enforcement nor the service community are going to get everything they want. And I would say, let me admonish you and others who may be in the audience that trying to do a balancing act to come up with something that protects the privacy of Americans as well as allows law enforcement to do their job, particularly against people who use the internet for criminal purposes, is going to be kind of a tough nut to crack. We tried it in the last Congress, and we weren't able to get the ball over the goal line. Let me say that I think the different standards between a warrant and a subpoena is outdated and probably unconstitutional. And I think we're going to have to require a warrant with probable cause on most of the stuff that you can get from a subpoena, at least in criminal investigations. Maybe not so in the civil ones, but at least in the criminal investigations. I also think that with that, 180 days is too short to require the retention of material. And I'd like to ask you both, Mrs. Tarangill and Mr. Littlehale, what time do you think we ought to have in terms of requiring a service provider or somebody who stores emails in the clouds to retain that material? And I recognize that this will just be an arbitrary time, just like the 180 days is.
Well, I will start by saying that data retention is a very complicated and tricky issue. It's not something...
Believe me, we know that.
And certainly, law enforcement's ability to get data is very important. The 80-day rule, I might also comment, has, frankly, in ECPA to do with sort of the ability to use one...
Can you just give me a time period? At least we know what we're talking about then.
I can't today, but we are eager to discuss with you and understand that part of...
Okay, I'm sorry that you can't today. Mr. Littlehale.
Let me suggest, Mr. Chairman, that the answer to that question is linked to service provider timeliness. Because in many instances in these cases, for example, in the commercial sexual exploitation of children case that we were just discussing, there are many layers of service providers that we have to jump through to identify that child victim. And so if I know that I'm going to get those responses back in 7 days each time, or in 3 days each time, then I don't need the records retained as long. Because I might not know until I get 2 or 3 layers of subpoena responses or search warrant responses back where I need to send a preservation request. If, however, those times are allowed to continue to be a month or 2 months, then my answer would be 6 months or a year in many cases, because it might take us that long to get to the records we need.
Okay. Now, I have a question to Mrs. Tarangill. The Fourth Amendment recognizes emergency exceptions. Why doesn't DOJ have a position on looking at or defining the life or limb exception? I think that it would be very advisable to codify that so you don't have a multitude of different court decisions on what is life or limb and what is not.
certainly happy to engage with the subcommittee and with Congress to talk about that area and any others that the committee would like to explore. Certainly an important exception and one that the government, both at the federal, state, and local level, make use of.
Well, you know, let me express my discomfort that you don't seem to have any answers to questions that have been asked, and it's not just by me, but by other members of the subcommittee, and this really shouldn't be any surprise to you that the questions were coming, because this is not a new issue. This is not the first hearing that a congressional committee has had on the subject of modernizing ECPA, and I would hope that the Justice Department, when they come back next time to talk about this subject, is that they can anticipate the questions and have an answer. You know, I can say that, you know, if this were a trial, there would be a lot of people that wouldn't be happy about the counsel at the trial being as ill-prepared as you have been. So with that admonition, let me say without objection, this hearing is adjourned.